Hello, everyone, and welcome back to Coffee with Craig, where we talk about firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program. Oh, by the way, and encourage your friends to do the same. And if you're watching us on YouTube or you're watching us on Facebook, make sure you hit that notification button. So that way you'll be notified as soon as we go live, and you can participate in the live chat as the program is taking place. Now, also want to remind you, Firearms Policy Coalition is a membership organization. That's right. We want to encourage you to join the Firearms Policy Coalition and support the work that we are doing here to fight for your rights, whether it's legislatively, whether it's litigation, whatever it may be, or whether it's just fighting in the media and getting information out there. We can't do it without your support. So all you got to do is go to joinfpc.org. That's joinfpc.org, and become a member today. As I always like to say, either you're part of the solution or you're part of the problem. Don't be part of the problem. Become a member today. And if you're already a member and you want to let folks know, hey, you just want to make sure folks know and see, hey, I'm a member of FPC and I want to walk loud and proud, then you need to go to fpcgear.com. That's fpcgear.com. It is the place to go to find all of your Pro 2A swag. It is a place to show where you can support the Second Amendment. Look, and the best part about it is every dollar that you spend goes right back into the fight for a right to keep and bear arms, which basically means you can support the Second Amendment and you can look good doing it. That's FPC. It's fpcgear.com. All right, let's get on to today's topic, shall we? Very, very interesting thing that has happened. As you know, the Supreme Court has made a decision when it comes to our right to bear arms outside of the home. But what a lot of people don't realize is how far-reaching that decision is, even beyond just the right to bear arms outside of the home. And with that, one of the things that they did is they set a new test. Basically, I'll get into the details of it, but they set a new test which is going to affect how all Second Amendment cases, all cases that are coming forward, should be judged. And that has resulted in an act where the Supreme Court has vacated a number of cases, including one dealing with an assault weapons ban. And to discuss this case and what they mean when they say it was GVR'd, we have with us Associate Counsel for the Firearms Policy Coalition, Mr. Bill Sack. Bill, how are we doing today?
Hey, Craig. We are busy.
I can imagine. All right, so I got to admit, when I first saw the press release and I first saw the thing talking about being GVR'd, the first thing popped in my head was GVRO, and I'm like, okay, what does this mean? I mean, I was just excited because of all the Pro 2A stuff coming out. But this is a huge deal. And I was wondering if you could kind of let the folks know exactly what you mean when you say GVR'd.
Sure. So this is one of those legal jargon things that we like to talk about in the Supreme Court jurisprudence world. GVR'd stands for granted, vacated, and remanded, in that order. So as you mentioned, we just had that big decision in New York State Rifle Pistol Association v. Bruen. So that was a case that the Supreme Court agreed to take up this past session, and we just got the opinion last week. So in addition to that case, there were 4 other Second Amendment cases that were up on the Supreme Court's docket that were up for certiorari. So that means that the case had gone up on appeal, and the appellants had asked the Supreme Court if they want to hear the case. So those 4 cases were Bianchi v. Frosh, ANJRPC v. Bruck, Duncan v. Bonta, and Young v. Hawaii. And we'll talk about what each one of those represents. And those were additional cases that we were asking, or other counsel were asking the Supreme Court to take up directly on the Second Amendment. And so what the Supreme Court did just yesterday on the 30th was GVR'd these cases. And so that means that they granted the petition for certiorari. So in granting that, they agree to take a look at the case. Then they vacated, which means they said the lower court's opinion, gone, thrown out. That's what vacated means. And then remanded means sent back down for the lower courts to reconsider. And so basically, in total, what this means is the Supreme Court said all four of these other Supreme Court cases were decided wrong because they were decided using the old test. And as you mentioned rightly, Craig, there's a new test that we've got now, which is text as informed by history and tradition. And so in GVRing these cases, the Supreme Court sent all four of them back down saying, lower courts, you got to do these over again. You get a mulligan. Use the right test this time. So that's where we're at.
So basically, it was like, yeah, no, you did it all wrong. We're going to give you a chance to do it right. Now, all right. So let me just throw this out there. So, what is the likelihood that these courts, that these cases have been sent back down to? What's the likelihood, and maybe you can talk about it with each case, that the decisions are going to come out differently based on this new standard?
Well, we think the likelihood's pretty good. You know, the prior test that most of the circuit courts had adopted before Bruen was an interest balancing test. And they were using a pretty watered down version of intermediate scrutiny. We talked about the different levels of scrutiny in one of our prior interviews.
Let's be honest. They were using rational basis, which is pretty darn irrational.
They were using a pretty low bar. They were requiring a pretty low bar of the government to prove that each one of these gun control measures was constitutional. So this new test sets a significantly higher bar. And so we are pretty confident that the government now has a significantly higher hurdle and a stronger burden that they've got to meet in order to show that any of these gun control measures are constitutional. Specifically this test, this history, text as informed by history and tradition test, it basically requires that the government now prove that there is some sort of analogous regulation that was in place at the time of the ratification up through the mid 1800s. You know, the Bruen opinion really kind of gives us some boundaries here and says, look, if there is not a similar piece of gun control or pervasive gun control in place from the 1790s up through the next following 50 years or so, and the government can't show that, then the gun control is unconstitutional. So it's a much steeper uphill battle for the government to prove that now under this test, when before all they had to say was, well, public safety is important and this kind of helps public safety because we say so.
Right, where really the burden of proof at that point was on the plaintiff, not necessarily on the government. And which seems kind of odd, because if the government's going to infringe on our rights, it ought to really be on the government to prove that either it's not an infringement or that it meets the test that would allow such a thing to happen.
Yes, I mean, the burden needs to be on the government. They need to prove that whatever they're doing meets constitutional muster, and whatever conduct it is they're seeking to regulate, whether it's prohibited or strongly regulated, falls outside the protection of the Second Amendment. They've got a much more difficult task ahead of them now under the new test.
But Bill, they've got to do something.
Yes, do something, Craig. Do something. Anything. We don't care if it makes things worse as long as we've done something.
Can you give me a brief sketch of each one of these cases? Basically, it's kind of what they're about, so the folks can have an idea of what of the various firearms areas of rights are possibly affected here.
Yeah, I mean, and these are big ones too. You know, like I want to make sure that the audience appreciates, like, we're talking about 4 cases at once in one interview here, but anytime outside of post-Bruen world, each one of these cases would be like huge, massive news, right? These are big issues. So the first case, which is an FPC-led case, which is Bianchi v. Frosh, is challenging the Maryland assault weapons ban. So in the Fourth Circuit, where Maryland resides, there was a case called Colby, which was basically the worst possible Second Amendment analysis you can imagine. And it was the binding Fourth Circuit precedent for Second Amendment analysis for the last decade or so. By GVRing Bianchi v. Frosh, the Supreme Court essentially threw out the Colby opinion and said Colby was decided wrong because it was decided using the old test, and Bianchi was by association decided wrong because they said they were bound by Colby. So this is big. It means that nearly a decade's worth of really crappy Fourth Circuit Second Amendment jurisprudence is out the window, and we're starting fresh. So we have a fresh look at an assault weapons ban that could get tossed out in Maryland and potentially be a foreboding for assault weapons cases all over the country. So that's a big one.
Excellent. All right. So what's the next one?
Okay. So the other ones. So we have ANJRPC versus Brooke. So this is challenging the New Jersey standard capacity magazine ban. Our Jersey folks are limited to 10 rounds in their gun, and that has been challenged. So we have a standard capacity magazine challenge coming out of Jersey. Same thing, decided wrong. That was upheld, but it was upheld on the old test. And so they've got to do a do-over, and now the government's got to show why restricting our number of bullets in our magazine has some sort of historical basis, which, as far as we're concerned, they're going to have a tough time proving.
Yeah.
The third one, and is kind of a sister case to ANJRPC, is Duncan v. Bonta. So this is our California standard capacity magazine case. This is another one, same thing. Magazine capacity restrictions were upheld under the old test, the watered down intermediate scrutiny test, which is out the window. So we've got another bite at the apple here for a lower court to do the right thing, and under the text as informed by history tradition test, toss out a magazine capacity restriction. Lastly, we have Young versus Hawaii, which is a carry case. So Hawaii has a carry permit requirement regime that's very similar to the New York regime. It was a May issue regime. And similar to how New York required good cause, Hawaii required some sort of urgent need, I believe was what their statute requires. But basically a finding that you had, in order to get a carry permit there, some extraordinary reason that put you outside of just the regular population's want for self-defense in public. You had to prove that you had some extraordinary need. And that gave really an ultimate level of discretion to the issuing authorities there. And that's precisely the sort of discretionary regime that Bruen said, no good, you got to go. So that carry regime should be changed in the very near future as well.
All right, now I'm curious as to why they would even need to redecide that one, because it sounds like, to me, a layman, the same issue as was decided in Bruen. Why they would need to redo it? Why not just put the two together and just say,
right.
Yeah, no go?
So what we have to remember, Craig, is when we have a case, even at the Supreme Court level, is that the holding of the case, the decision in the case, is only binding as to the parties that are in that case.
Okay.
Now, because Supreme Court jurisprudence makes binding case law for all of the other courts in the country, if there are other similar cases, other courts are bound to follow the lead that the Supreme Court lays out.
Got it.
But those courts have to make those decisions first. Right. So the issuing bodies or the law enforcement bodies in the various states that still have these may issue regimes, they don't automatically have to stop doing what they're doing just because the Supreme Court decided Bruen. Mm-hmm. But what they have to know is if you keep enforcing this and we challenge it, the court in which we challenge it is going to be bound to follow the Bruen opinion. So you can change it on your own, or you can wait till we sue you. Either way, you're going to lose.
Excellent. Actually, that's something that as long as I've been doing this, that's something that I never knew. Or as long as I've been following this. I don't do it for I don't do that for a living. That's a little bit more brain power than I think I have.
More than I have most days too, to be honest with you.
Well, that is phenomenal. So it sounds like not only do we have a lot to celebrate, but it also sounds like we still have a significant amount of work ahead to do. And it also sounds like it sounds like we've got a little bit easier road than we otherwise would have had.
Absolutely. I mean, look, we cannot understate how big this Bruen decision is. This is massive. Let's remember that in the history of the Republic, the Supreme Court has only ruled on the Second Amendment 3 times. We've got Heller, we've got McDonald, and now we've got Bruen. So this is nothing short of absolutely historic. We are very much living the dream right now. This is what you and I and the rest of the FPC legal team and really the rest of the Second Amendment movement have been fantasizing about and living for the last 2 decades, right? Now is the time.
It is interesting you say that, because when you look at it that way, the Supreme Court, when given the opportunity to rule on the Second Amendment, has always ruled on the favor of the people's right to keep and bear arms, and not
we are
those
3
who
for
would,
3.
Yes, not those who would seek to restrict our rights. Hey, if folks want to follow your work here with FPC, where do they go?
So go to firearmspolicy.org. There you will find everything that is FPC. And if you want to go directly to our legal page, you can go to fpclegal.org and you can read about Bianchi, ANJRPC, Duncan, Young, and all of the other cases your FPC legal team is involved in.
Excellent, folks. Like you said, you can go there, or you can simply go to fpc.org. Now, here's the great thing. Look, if you haven't already done so, please make sure you sign up for the emails. It's real simple. You just put your email in there, put your zip code in there, and bam, you will receive all sorts of alerts about what's going on. And trust me, FPC is reporting on it and talking about it before anybody else. These folks are, I will say this. They are the, in my opinion, we are the purest organization when it comes to Second Amendment and Second Amendment advocacy. I always say we're not a hunting group. We are not a group that specializes in, we don't do what's it called, weapons reviews or firearms reviews or product reviews. We're not talking about we're not dealing with public safety. We're not raising money for candidates. We are specifically talking about and fighting for your fundamental right to keep and bear arms. I always tell people I'm a Second Amendment civil rights advocate as a member with FPC, and I want to encourage each and every one of you to become one of those as well.
Thank you for having us, Craig.
All right, sir. All right, well, that is going to be it for today's episode of Coffee with Craig. We very much appreciate you tuning in. We appreciate you liking, sharing, and, encouraging your friends to do the same. Remember, this is a fight for our civil rights. We got to use them or we're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.